Healthcare is too expensive. Employers are offsetting costs onto their employees. Who will make health benefits affordable for hard-working Americans and their families?
You will! This is the Empowering Plans Podcast, a show dedicated to helping you once again emphasize the benefits in your benefit plan. Now prepare to learn,
Plan,
save,
and protect with the FIA Group.
Hi, welcome to Empowering Plans with the FIA Group. My name is Cindy Merrell, and today I'm joined by Bryan Dunton. Say hi, Bryan.
Hi, everyone.
So, Bryan, I was so excited when we started talking. We were trying to figure out what we wanted to talk about today, and something that I thought was really important and neat about you and I having this podcast regularly now is FIA is all about collaboration, and that's one of the reasons I love working here is we always get to collaborate. Bryan and I work on two separate sides of the FIA, the proverbial FIA house. So he is over a consulting attorney and doing a fantastic job and dealing with all of the consulting questions that come across. I am a subrogation attorney. And so on the subrogation side, we deal with all of the healthcare subrogation and it doesn't happen all that often, but when our worlds collide, sometimes they collide on a pretty big scale. So I'm just grateful to have Bryan and his team. Whenever we have a question for the consulting team, they are fantastic. So today, one of the things that collides, one of the topics that bring both of our sides of the house together is when we have a subrogation file, a claim going, and then there's also a question for unpaid claims. And that's when this thing called the NSA, the No Surprises Act, kicks in. And Bryan, I'm going to defer to your expertise. Can you tell me a little bit more about the NSA?
Yeah, happy to, Cindy. So the NSA was signed into law as part of the Consolidated Appropriations Act back in 2021. Some key features of it are that it prohibits out-of-network providers from balance billing patients for certain services that are furnished in an out-of-network facility. It also applies to in-network providers under certain conditions as well, and it's generally tied to advance notice and consent requirements. And without getting too into the weeds here, it also established a federal independent dispute resolution process, which we call the IDR process, to address instances where the plans and out-of-network providers disagree on the payment amount. So it preserves coordination of benefits, but only to the extent that it's not inconsistent with providing emergency benefits. And that's really one of the key areas we noticed that there seems to be a misunderstanding with the NSA is that because it's best known for protecting people from those kind of surprise out-of-network bills, people assume that it simply doesn't apply to in-network claims at all, or have any application to a plan's right to exclude claims. But the reality is quite different, as you know. The regulations also contain an extremely broad protection that applies essentially to any emergency claim, regardless of that network status.
So what I wanted to talk about is that with the NSA coming into play, we have cases. I work on a better level of examples. One of the examples that I have is a case. It's a hypothetical case. I'm not trying to identify anybody. We're going to call Bob Smith as our member. It's the plan member of a self-funded ERISA plan. And then Bob gets injured in this catastrophic loss when he gets hit by a semi-truck. So Bob's going down the highway, the semi-truck is reckless and hits Bob. And Bob goes away and he's taken away to the hospital and he's inpatient for another month because he has some horrible catastrophic injuries. What we see happen a lot of times on our end is the plans will pay, because it's typically like an auto approval under a certain threshold, they will pay small dollar claims for these trauma related dates of service. And so what we do is we will scrub the plan's data and discover that Bob was injured in this MVA, in this motor vehicle accident. And then we start working with the member's attorney, and we find out, and sometimes we have some visibility if there's a large trauma claim that has been unpaid by the plan. So what happens is when we find out that there's this member's attorney is typically at that point pretty frustrated because there's these large bills that are unpaid by the health plan. And we are trying to kind of help bridge the gap between the member's attorney and get them in contact with the plan, or typically their TPA, to discuss any unpaid claims. And then we get on a call with our clients in the group, and the group is typically asking if they actually have to pay these large trauma claims, because there's, in theory, potentially a third party who's liable for those claims. So what happens is when that we have to bring in our friends over here at Bryan and his team to talk to the plans about the NSA. And one of the things that typically comes out is that liability in most of these cases is not usually clear cut. In my example with Bob, the trucking company is not, jumping over trying to get to accept all the liability right away. Ordinarily, what happens is it can take years for liability to ever be determined. And while that's playing out, I mean, it can easily take 4 years, 5 years for there to be any liability determination. There's these large unpaid claims. And though we accept that there is potentially third-party liability, just because there's potential third-party liability, does that actually mean that the plan can exclude those claims? So Bryan, can the plan deny for some of this information? A lot of times we were being asked about what's the policy limits, and is there med pay, and all these things that we might not always have the answers right away. And like I said, a lot of times most states, they don't have to disclose policy limits, or it might not be a mandatory personal injury protection benefits state or med pay state. So do they actually can they deny those for failure to provide that information?
So a plan can deny for failure to provide information that is necessary to adjudicate a claim, or alternatively, they can adjudicate and pay subject to later recovery rates. What the plan can't do, though, is pen the claim indefinitely while it investigates whether that hypothetical third party coverage is available, or those developments arise. So ERISA claims procedures rules require really timely decisions on this. It's all very clearly laid out. And if there's additional information needed, the plan needs to tell the claimant exactly what's required and why. When you start talking about emergency care, that's when it implicates the NSA, and further constraints are then applied to that process. The departments themselves have interpreted that the NSA prohibits a plan from denying emergency services based on a general plan exclusion. So any exclusion that would otherwise apply to items, services other than emergency care itself. So in our view, anytime you have some kind of source of injury exclusion, those so-called illegal acts or other broadly worded ones that say injury arising from, those function effectively as general exclusions in this context, and therefore they can't be used as the basis for denying an NSA protected emergency care claim.
Well, that's helpful. Thank you for giving us a little bit more information on that. And one of the biggest issues that I come across is that there is a lot of plans deny for third-party liability, and that is what I'm understanding you're saying would be considered, or potentially considered, a general exclusion. So that is really helpful to us to understand what the plan's obligations are. What I want to talk about next is a little bit more of the potential risks to a plan. We call it pend and pursue, or pay and chase models. And one of the things that we talk about is the pend and pay are the ones when they're waiting. The plan typically will deny for accident details and then they pen those claims, and then they will pay them once they receive the additional information. The pay and chase model is what some of our clients choose to do because of these potential risks. And when I say pay and chase, they will pay the claims and then pursue recovery exclusively through the subrogation reimbursement provisions of the plan. And what I see a lot of times where we have real big problems, and most of the time when Bryan and I and his team are talking about the NSA and the subrogation claim, we're talking about large catastrophic injuries, and that typically involves stop loss. And one thing that sometimes plans who choose the pend and pay model, one of the risks to the plan is that most stop loss contracts have very strict deadlines that a plan must file a claim or reporting a claim to the stop loss carrier. And sometimes if there's a pend and pay model, they will lose out on those stop loss benefits because they didn't timely file with their stop loss carrier. They also may, if the claim is too old, and I mean, I've seen some of these claims go 2-3 years out, the plan may lose out on their network discounts. And that's a big one. That is a big risk to a lot of the plans that choose the pend and pay model. I do want to circle back to our friend Bob. Poor Bob. He was driving down that interstate and he got hit by the semi, and then we're trying to subrogate this claim. And one of the other risks that plans have is if Bob settles his claim before the plan pays this large trauma claim, there is a case out of the Supreme Court that says that the plan would have to, if the funds get dispersed, so if the member is represented by an attorney, so if Bob hired an attorney, the attorney settled the underlying claim and received the money. So let's say Bob settled his case for policy limits of $1 million. And the plan had only paid all of those small dollar claims. So let's say they paid, I don't know, $15,000 in claims, and then they chose the pend and pay model. They still have $1 million claim outstanding. When that case settles, and they can sometimes settle very quickly or take a long time, you never know, but typically if it's pretty straightforward with these catastrophic injuries, if there is enough coverage or not. But if the funds are dispersed to Bob by his attorney or from the insurance carrier, there is a Supreme Court case that says the plan would have to be responsible for tracing those funds to an asset. So let's say Bob really he settled his case really quickly. The plan hadn't paid that claim yet, and the funds go to Bob, and he goes and spends $1 million in lottery tickets, or spends $1 million in, I mean, let's just name it. He pays off his credit card, or does all these different things, and we can't trace those funds. It's very difficult for the plan to get those settlement funds back. So once those funds go to Bob, it can be very challenging, not impossible, but very challenging and very costly to the plan on the back end. And they were ultimately going to be likely to have to pay those claims anyway. So it's a risky model. And this is something that we have to, it's a challenge on our side as of the house. And I'm just so grateful that you guys are here to give us some guidance and our clients some guidance on the NSA.
Yeah, thanks. Thanks, Cindy. So I think it's really important too to remember that there is another viewpoint out here on this. It's a minority viewpoint, and that is that if the exclusion is truly specific and drafted to apply even in emergencies, that it could still operate. But that is the minority viewpoint. It's not the viewpoint we hold here at FIA, because there's no direct post-NSA authority that's come out to resolve that question. So from our end, we recommend a much more conservative approach, which is to adjudicate and pay those emergency claims consistent with the provisions of the NSA. Reserve those kind of exclusion arguments for, the non-emergency settings or for those really escalated fact-specific reviews. That kind of ensures for the plans that they're making that good faith, reasonable interpretation effort that's required of them by law. And it does indeed seem reasonable since the text of the regulation itself is pretty clear on its face and in lieu of that lack of additional guidance that we have right now. So.
Well, that's good. It's important to recognize that there are other viewpoints out there, but as always, the thing that is the best part about FIA, like I said, is our collaboration, our collaborative approach with our clients and within the company. And it's wonderful to have that opportunity here, because I know that's not available everywhere. So just to have that resource is wonderful. So thank you so much, Bryan, for joining us today. And it was just another episode of Empowering Plans with the FIA Group. Thank you.
Thank you.